Commonwealth versus Butler.
Good man.
Ms. Lovell?
Good morning, Your Honors. Amanda Lovell for the Commonwealth. With me is the trial prosecutor in this case, Catherine Tucker. The defendant was charged with 4 counts based on 3 different incidents, 3 different periods of time of assault, or of attacking the woman who was his girlfriend and had been for approximately 7 years. In the proof of those charges, the Commonwealth also was permitted to offer evidence of a black eye and of 2 restraining orders that the victim had taken out against the defendant that were not related, that were not charged incidents. That evidence was described in the appeals court as evidence of the nature of the relationship, the entire relationship, that in the Commonwealth's brief to the appeals court. The prosecutor argued that evidence was relevant to the trial judge in her motion by talking about the hostile relationship between the parties.
Ms. Lovell, I'm trying to think of guidance that we give to trial judges. In other words, if the appeals court is questioning what the trial judge is doing quite appropriately, I want to make sure that whatever we do here, we give appropriate guidance. It seemed to me that in part what was happening in the cases that I looked at was that there was the nexus was between the victim and the defendant. In other words, it was that relationship. But the Commonwealth agreed that to the extent that we admit any evidence like this, which so clearly could be considered propensity evidence, would be limited to where it concerns the relationship between the victim and the defendant.
In domestic violence cases...
Well, I'm thinking of, it doesn't necessarily have to be domestic violence. I'm thinking it could be an employment situation. It could be, other kinds of situations. But I'm trying to think of what the limiting principle here is.
It's certainly evidence of some kind of a hostile relationship between the defendant and the victim is a special category of the kinds of bad acts cases. There would be certainly evidence that I could think of that would involve someone other than the victim that would be admissible, certainly for pattern of conduct cases, some of those other things.
I'm thinking of the particular jurisprudence that says to establish the nature of the relationship.
Yes, that would, except in extraordinary circumstances, perhaps, that would be limited to the...
So that should be an exception. I mean, in part you argue that this goes to motive. I don't see how it goes to motive at all.
Well, the court has been holding that it does go to motive for about at least 115 years.
But whether it goes to motive, why is motive relevant? I mean, if someone beats up somebody else, why is the motive? What does it matter what the motive is?
Excuse me, Your Honor. I didn't mean to cut you off.
That's all right.
Motive is always admissible. Motive is always relevant to explaining to the jury what happened. And
wait a minute. I think in the cases, most if not all of the cases, they are murder in the first degree indictments, whether or not they were convictions of that. So motive is central, correct?
Motive is central?
Is central in the sense that it might go to, any of the, we may characterize it as motive, but whether somebody acted with deliberate premeditation, for example, that's not motive, but if you show that somebody's done this before and planned and knew and...
Isn't it really pattern of conduct? Pattern of conduct?
It is, some of the case law, I think, has if I may...
Yes, but if it's pattern of conduct, isn't pattern of conduct dependent upon a unique set of factors? And because somebody beats up his girlfriend is hardly unique, as we've seen. I mean, if somebody cuts off an ear, yes, that's unique. Or somebody does a specific thing, like I'm cutting out a heart, I remember in Rosenthal. But that somebody beats up a girlfriend isn't... I mean, we've got hundreds of those cases.
Well, certainly the modus operandi cases talk about where the evidence is admissible for identity.
There's no question of identity.
That's correct,
But
yes.
this type of
Yes.
thing is a modus operandi. They're not using a peculiar method. It's
I would
just
agree.
that, something goes wrong, he beats her up.
And I find that motive is the most useful way of describing it, although as I cite in the brief, it's also talked about as hostile relationship and entirety of the relationship. And
Explain that.
Certainly. As the court has been finding over and over and over.
Well, obviously, we're confused because that's why we're here. So
Certainly.
explain to me why this
Okay.
is relevant to motive.
What the jury would be left with, absent the evidence of motive, is that these people have been in a relationship for 7 years, and suddenly one day, the defendant decided to hit the victim in the face.
Yeah.
And to put that into a context, and I don't think it's any different from the first-degree murder cases, because as a person who used to be in my office and is now sitting on the bench once said, a murder is really an assault and battery, an ABDW with a body. The crimes are the same. The kinds of actions that this defendant, in fact, in one of the uncharged acts that did not come before the jury, where he set her on fire, it very easily could have been a murder case. So the proof between what you need to show to prove a murder, as far as motive goes, and what you need to prove to show an assault and battery, is not different.
But for murder, you're looking to show a specific intent. For assault and battery, you're not.
Well,
and motive is very important, and it's probative of a person's intent, of their specific intent. How is motive probative for a general intent to commit an assault and battery?
It's still probative to show why this thing happened, to have the jury's question that any reasonable juror would have is, what's going on here? Why would this happen?
But that would be true.
Answered.
But that would be true in so many cases, wouldn't it? I mean, what we ask jurors to decide every single day is take a look at just these facts. And we spend a lot of time excluding all kinds of surrounds so that, precisely so that the jury, if and when they find a defendant guilty, will find them only because of those facts. In other words, if he in fact assaulted her that day, the Commonwealth presents evidence of that.
And
What is the motive? Could you describe the motive here?
I would say the motive is the hostility in the relationship.
But that's descriptive of the act. What is the motive behind this man's wanting or hitting his girlfriend?
Well, I would argue, although it's nowhere in the record, I would argue from the domestic violence literature that the motive is his desire to control her, which is very much represented in the facts of this case.
Now, the judge allowed this evidence in, and if I've got this right, the judge told the jurors that they could only consider it insofar as it tended to show motive, opportunity, a state of mind, intent, preparation, planning, a pattern of conduct, or the nature of the relationship between the victim and the defendant.
Yes.
That's mighty broad, isn't it?
Well,
I mean, doesn't that cover it? Everything?
it excludes propensity,
Well,
and
yes.
that is and that's the concern.
Well, pattern of conduct? I mean, this is not an identification case. Pattern of conduct, that seems like propensity to me. Is this consistent with prior conduct?
He did it before, therefore he did it again.
Understood.
Ms. Lover, let me
Yes.
suggest this. I'm sorry, do you want to just answer Justice Cordy, and then I'll ask you the next question?
If I might, please,
Sure,
yes.
of course.
There are two things regarding that. One is what the prosecutor argued to them was very specific, that this goes to his motive, it goes to his state of mind, it goes to lack of accident. And so while they heard from the judge that there were broader categories of things that it was admissible for, the argument that was made was very specific to that. And I would also just draw the Court's attention to...
Lack of accident?
Lack of accident, yes.
Well, how could the lack of accident?
Yes.
How was accident in the case?
Well, it came in it came in because there in many because he didn't accidentally hit her in the face. I mean, he didn't. That it was showing that he didn't. That he intended to commit these acts. That.
Well, was it a well? I mean, it seems to me you have this. You have. This is classic. You have the victim's spontaneous utterances, which
Yes.
were admitted for the substantive purposes that said he did it. You have her on the stand saying he didn't do it, and it's a credibility issue.
Yes.
And so it seems to me that you're trying to establish that they had a stormy relationship so that the jury will believe her first statement rather than her second statement.
Yes, that's correct. And in
But
a volatile relationship...
Another way of saying that is that it's a little unusual in the general jurisprudence. It's a little unusual for people who are victims of crimes not to testify. One of the problems in this case is that this victim, the Commonwealth called her, but she was clearly denying that anything had happened to her. There are two sets of circumstances that I can think of off the top of my head where it is unusual for victims not to testify. The first is in cases of domestic or related violence, and the second is where there's witness intimidation. Is it not appropriate to try to fashion a jurisprudence that says it is acceptable for the Commonwealth to explain to a jury? It's not that the jury is worried about why did this come out of the blue, because many events come out of the blue, but why is this particular victim denying that something happened to her?
Yes, that is certainly reasonable.
And it seems to
be
me
doing.
that rather than this nature of the relationship, it's really quite a specific focal thing, as we have tried to deal with witness intimidation. And I don't know what that bright line is, but that's what I'm looking to you for, which is if you're going to tell trial judges in this kind of circumstance. Now, I don't think that that's what the Commonwealth argued here. I mean, as far as I can understand from the appeals court's decision, you argued bias. I mean, I don't know whether what you were trying, I don't know what bias is.
I believe that the argument of bias did go to explaining why the victim was recanting as opposed, rather than testifying as the Commonwealth believed was truthfully. And it was showing that, I keep coming back to the language, but the nature of this relationship, their entire relationship.
And nature of the relationship is germane, it seems to me, not simply to how or why the crime occurred, but very much, as the Chief Justice's question suggests, part of the context in which the jury can assess she makes an accusation and then she retracts it, and the prior history that suggests nature of the relationship sheds some light as the jury is trying to sort out, is the recantation the truthful version or is the spontaneous utterance the truthful version? What is going on in this relationship? Did the Commonwealth use the words nature of the relationship?
At what, to the jury?
To the
jury,
the judge. Or the judge or the appeals court?
Nature of the relationship or entire relationship to the appeals court, hostile relationship to the judge, and I believe motive, intent, state of mind to the jury.
Did she testify, didn't she, but she recanted?
Yes.
Okay. And
yes,
then the officer brought in through hearsay all of the stuff we're talking about today?
Two officers and her daughter recounted the excited utterances.
Is there a Crawford problem here?
No, because she testified. In fact, this is exactly the kind of case you're going to be seeing more post-Crawford. Because
well, that's my concern. In the past, well, often you're not going to get a victim to testify in any event.
Yes.
I mean, you might. I mean, the Commonwealth has extraordinary powers. I mean, so does the defendant, to call a witness. I mean, you can subpoena a witness, but and that's why I think of witness intimidation. This is a form of witness intimidation. It's not the classic form of witness intimidation, but it is a form of witness intimidation where people are afraid to tell the truth, or even if they're not afraid, the nature of the relationship is such that she may in fact be telling the truth at the moment that she testifies. Her memory may be that she wasn't assaulted or that she did something to get even at him. I mean, so this is not going to lead to a whole slew of perjury charges.
That's a possibility. I would mention that in the prosecutor's closing argument, when she was talking about the victim's credibility, which of course was central, and which of the victim's statements they should believe, she mentioned to the jury that when they saw the victim testify, they saw that she, after she would, in my words, explain away something that she was being asked about or her prior, about these cases, she would then look over to the defendant as if for approval. And I think that supports very much what
So what you're saying is that in this case in particular, where a victim recants and then gets on the witness stand and recants, this kind of evidence is very relevant within a judge's discretion to show the context of their relationship and that, and as I think we've mentioned, that in fact in the past she's done this before.
Yes. Yes, that would certainly be absolutely permissible
And that
grounds for
she's
this to
under
be
his thumb and all that kind of stuff.
Yes.
I do think that the language, the nature of the relationship, I mean, we have to find, some way to, as I say, to make it clear what we're talking about. And there may have to be a voir dire, there may have to be a threshold showing. The judge may have to examine the witness to ascertain whether or not, let me put it the other way around, and I'll ask defense counsel. We know that there are cases, particularly when there's a breakup of a marriage, that allegations are made, or breakup of a relationship. I don't mean to suggest it's only a marriage, where allegations are made which are not based on reality. So somehow we have to try and provide guidance for judges as to when they do and don't admit this.
I think that would be helpful. If I could just very quickly mention that this trial judge was concerned about what evidence was probative and what was prejudicial, and in fact would not permit photographs of the burns that the victim received in a subsequent bad act to be admitted because he found them too prejudicial. He was watching those issues in this case.
Thank you, Ms.
Thank you.
Mr. Diabou?
Morning, Your Honors. To put in context the prejudice to Mr. Butler by the admission of the bad acts, I do think that the Court should examine in the Commonwealth's opening and in its close, the Assistant District Attorney prosecuting the case told the jury, don't believe her. She has a reason to lie for this man. She has every reason to lie for this man. I suggest to you that she was not telling the truth. She was telling the truth on the day she spoke.
But what is wrong with the judge's ruling? All evidence that comes in from the Commonwealth against the defendant is, quote, prejudicial to the defendant. Would it be an admission, a confession, or this kind of thing? Where did he abuse his discretion, the judge?
Well, first off, he abused his discretion in let me say this. I contend there were 6 bad acts in this case. The Commonwealth contends that there were only 3.
Well, maybe there were 6. So where did he abuse his discretion letting in the 6?
First of all, pursuant to Commonwealth v. Leonard, before the Commonwealth should have even been permitted to ask the witness about these bad acts, it should have made a preliminary showing to the judge that it was going to be able to prove that the acts were committed and that the defendant was the actor. And it couldn't do that. The Commonwealth couldn't reasonably assert to the judge that this witness, who I know has recanted, and I know, and I'm going to instruct the jury, or I'm going to suggest to the jury is a liar, the Commonwealth couldn't in good faith tell the judge, but she's going to admit to these other bad acts. And in effect, her denials, were essentially telling the jury, look, just
What was the evidence of the prior bad acts? How did the evidence come in then?
Well, the 3 that the Commonwealth...
Okay. Any of them. Take one. How did the evidence of a prior bad act come in?
There were 2 restraining orders that were admitted.
Okay, so that was admissible evidence, right?
Well, I suggest it wasn't admissible because it didn't meet the second requirement of Leonard, that it was not relevant to any issue at trial.
But it takes care of your first problem, that there's no admissible evidence. There is a restraining order.
Yes, and the 3rd bad act that the Commonwealth concedes was admitted was a June 1998 black eye situation, exactly identical, I submit, to...
And how did evidence of that come in?
Through an officer...
Who saw it?
Who saw her, and
Okay.
she made a statement. He said she had a black eye and told me she just came from the defendant's apartment.
Okay, so why do you say that the Commonwealth did not have admissible evidence to establish the prior bad acts?
For those 3, it did.
Oh, okay.
Well, except I would submit that with regard to that June 1998 black eye, there wasn't enough because there was no evidence and there was no testimony, and the officer never testified that, oh, and she said Michael Butler did this.
Was right outside of his apartment, though, wasn't she?
And wasn't that
Yes.
part of her spontaneous utterance for some, I must say, inexplicable reason, excluded? I mean, I may be misunderstanding the different incidents, but I had thought he was starting to testify about more that she said, and the judge sort of cut him off. Sounds like there was more of that to that spontaneous utterance that, I say, for some inexplicable reason, the jury didn't hear. Or am I confusing the incidents?
It's not my memory
I
that...
apologize if I am.
It's not my memory that there was more to that incident. It is my memory that the judge then instructed the jury, you know, you've just heard about other bad acts allegedly done by this defendant, and to me what the judge said was, you know, overstepping what the actual testimony was in that regard.
Well, at least in the appeals court opinion, there's a footnote that says the prosecutor was not permitted to ask the officer if Jones told him how her eye had been injured. So I assume the prosecutor wanted to ask the next question, what else did she say about how she was injured, and the judge didn't allow that question to be asked.
Mr. Dion, perhaps I should have asked Ms. Lovell this, but I want to make sure that the Commonwealth doesn't get to change its theory as it goes along in response to whatever the questions are. I was perplexed because I haven't read the briefs in the appeals court, but I was perplexed by the following statement of the appeals court. Nor does the Commonwealth argue that the prior misconduct was properly admitted to show motive. Is the appeals court saying that in the appeals court that the Commonwealth was not arguing, quote, motive?
The Commonwealth was, to this court, argued motive.
But not before? It argued bias, as I was trying to work out. It argued bias, and it argued. Well, as far as I can see from the appeal, I was just perplexed, and we can go and have a look. But I mean, we don't. As a general matter, you have to make whatever arguments you're going to make in the trial court, and explain why you want it admissible. Were you trial counsel? I don't mean to put you on the spot.
I was not trial counsel. It's my memory that to the appeals court, the Commonwealth was using language about a hostile relationship or the entire relationship, and language of that nature. I mean, I can't. Okay. I really can't state with certainty that they didn't say motive at one point or another.
It may be a question of semantics, but if you talk about the entire relationship, wouldn't that include the motive, the nature of the relationship? Isn't that broad enough to cover how they interacted, their relationship, and?
I mean, I would say that it's almost so broad as to not have any meaning, Your Honor. I mean, entire relationship, I would say, is just a substitute for the prohibited kind of logic. I would say that phrase, entire relationship, just means, yeah, you know what kind of guy he is, you know what's happened before, he beats his girlfriend, and that's their relationship.
Again, the appeals court is very clear. And again, I want to have a look, but the appeals court says here the prior bad acts were not relevant to the case, and this is the quote, and were offered merely to show the defendant's propensity to commit the crime. Is that, I mean...
That's my contention,
Well,
Your Honor.
Could I ask you to shift to the issue of the nature of the relationship, seems to me, is germane not simply to how or why the crime occurred, but to the jury's assessment of the alleged victim's recantation of her prior statements and her testimony on the stand. And I take it, she's confronted with these restraining orders, and again she tries to say, well, no, that didn't happen. Yeah, I filled that out, but that didn't happen. So to let them see, what is this, what is the nature of the relationship as it pertains to her making of accusations followed by recantations, which is a critical piece of this case.
Again, I think the Commonwealth characterized that notion that you're calling nature of the relationship. I think they characterized that as bias. They wanted to show the jury she's a biased witness. That's why she's saying these
It's
things.
a form. Bias would be another word. I think perhaps not as good a word, but a possible word. Whatever word you put on it, why is it so irrelevant that it's an abuse of discretion for the judge to let
Because
it in?
it was the Commonwealth itself that created the situation. The Commonwealth called Ms. Jones as their own witness.
Well, of
Ju-
course-
They have to nowadays under Crawford and Gonzalez.
Well,
They can't
I
put her
suppose-
spontaneous utterances in the wake of Gonzalez unless they call her.
I suppose it would be an interesting question whether they need to call her. They could have her available, and the defendant could decide whether or not to actually call her and cross-examine her or not. I don't.
No, that's not the way Crawford was.
That's not the way it
I must say, Mr. Diablo, I am troubled by the judge's instruction. The judge starts off with a very good instruction. You know, you can't consider it for this, you can't consider it for substantively, but even if you accept, I think, the limiting principle that Justice Sussman and I are trying to craft here, to say that you can you can consider the evidence solely for mode of opportunity, pattern of conduct, state of mind, intent of the relationship. I mean, that's just about everything but the kitchen sink.
Well, and that's, I think, I submit that the Commonwealth never articulated one particular reason to the judge why this evidence
Commonwealth was
would
just
come
throwing
into
the
that
whole,
exception.
whole thing about, and if anything stuck, that was fine, but we don't have to really.
And I would suggest that the judge did not articulate any particular reason to the jury as to.
Did the defense counsel object to that instruction? Were you the defense counsel?
I was not the trial counsel.
Did the trial counsel object?
I don't know that he objected to the instruction itself, but he did object to the admission of the evidence.
Well, that's two different things. You know, if he thought this was too broad, which it probably is, I mean, you might as well just send the jury in with each one of them with a copy of Liakos on evidence and say, figure it out. But you've got to object to the instructions separately. And you can't remember whether he did or he didn't?
Well, I would suggest that regardless of whether he objected to the instruction.
No, I know he objected to the evidence, and that's preserved. Okay.
With respect to the instruction, even if it were a substantial risk standard, I don't think the court could fairly say that it wouldn't have had an effect on the jury had they not been more specifically instructed. I would.
I mean, one of the interesting things in this case, which is a little unusual, but not that unusual, is that the jury obviously passed through the various indictments quite carefully. I mean, this is not a case where the jury went out and came back and, guilty on everything.
Yeah, didn't they acquit him on some things?
Yes, they did. They acquitted him on.
They didn't get bamboozled by this instruction.
Well, I don't know that we can know that, because maybe they would have acquitted him on the second assault and battery charge. Maybe they decided just to compromise. We don't know what to make of this. We're hearing all this evidence. We'll convict him on this one. We'll acquit him on this one. I don't know.
And indeed, the matter in which he was acquitted, as I recall, at least from the briefs, there was actually police officer testimony which was inconsistent with the victim's spontaneous utterance. So there was a separate basis on which the jury could anchor some conclusion here.
That is correct. The defense called a police officer witness who had made observations at the time which
were inconsistent with the spontaneous utterance that the Commonwealth offered.
That is correct.
Which suggests that in the absence of that evidence, they found her to be credible, or found her spontaneous utterance in the first assault and battery to be credible, because there was no contrary evidence, I suppose.
Well, it would suggest that they believed the police officer testimony as to her first spontaneous utterance, and there was nothing to rebut that but her own testimony, which apparently they did reject, as they were asked to do by the Commonwealth. I would, as far as the Commonwealth's contention, it helped the jury answer the question, why did this happen? Again, I submit that that's just another way of saying that it happened because of a propensity that he had, and this is their relationship, and this is what he does. And I would suggest that that is also should have been prohibited.
Was there any suggestion by the victim when she testified here that she had a black eye because she'd fallen down the stairs, or was there any? In other words, the prosecutor did argue that this wasn't an accident. What he did was intentional. Did she suggest that?
Her reasons were that to injuries to her lip, she would testify that using a glass pipe to smoke cocaine,
she had
cut herself. She also testified that she frequently gets injured when she's in base houses. So, I mean, I suppose to the extent that biting on the lip would have been accidental, yes, but
I thought she said she'd been in a fight at a base house where she was doing drugs.
In a base, yes.
Right, and that explained her injuries on the evening. That was her testimony, not her spontaneous utterance. Her spontaneous utterance is that her boyfriend just punched her.
The spontaneous utterance, yes, I understood.
And her testimony at trial was that she'd been in a fight in a place where she had been doing drugs.
Yes, I understood the question to be whether she had offered any excuse, so to speak.
Yes, because that, again, is not unusual.
But she did not offer an excuse with respect to, Mr. Butler did this accidentally.
No. But, I mean, I think, I haven't read the prosecutor's closing argument in full, but I'm looking to the part that the Commonwealth cites in its brief, and I was just trying to understand why the question of accident comes in, and I think what the Commonwealth may have been saying is, if somebody cuts their lip, on a glass something, whether you'd use the term accident, it's to cover that this wasn't an intentional, fist to the face. Thank you, Mr. Diablo.
Thank you.